Right, good afternoon everybody, and thank you for joining this session. I'm going to focus today on disability discrimination, with a particular focus on discrimination arising from disability. And I just want to recap on disability discrimination generally, because it's quite a complex area. It has a number of different strands to it. Some of the strands are similar to other types of discrimination, such as sex discrimination or race discrimination, but there are others that are unique to disability discrimination. And as a starting point, and to set the scene for this talk, I want to take us all back to the House of Lords decision in the case of Fife v Archibald. Now this is 2004, so this is 12 years ago. And Lady Hale, who was in the House of Lords, which has now subsequently become the Supreme Court, talked of the then Disability Discrimination Act. And what she said about it was this: this legislation is different from the Sex Discrimination Act and the Race Relations Act. In the latter two, men and women, or black and white as the case may be, are opposite sides of the same coin. Each is to be treated in the same way. Treating men more favourably than women discriminates against women. Treating women more favourably than men discriminates against men. Pregnancy apart, the differences between the genders are generally regarded as irrelevant. The Disability Discrimination Act, however, does not regard the differences between disabled people and others as irrelevant. It does not expect each to be treated in the same way. It expects reasonable adjustments to be made to cater for the special needs of disabled people. It necessarily entails an element of more favourable treatment. The question for us is when that obligation arises and how far it goes. Now that does set the scene to today's talk. That was 14 years ago, and there is this concept of people with disabilities. In order to accommodate them in the workplace and to enable them to access the workplace at all, there needs to be more favourable treatment. And we'll see some of this arising in the case law. So in terms of the content today, I'm first of all going to quickly remind us of the types of disability discrimination claims that can be brought, with a focus on how those other strands of discrimination relate to discrimination arising as a consequence of disability. I'm then going to focus on this concept of discrimination arising as a consequence of disability. It's quite a mouthful, but this strand of the discrimination law is relatively new. It was introduced by the Equality Act 2010, but it is fast becoming a regular feature in claims in the employment tribunal. So at the moment, we are seeing roughly one successful claim for discrimination arising from disability being upheld in the tribunal each week. So that's approximately 50 annually. And to put this into context, in recent years, bearing in mind the drop in claims in the tribunals as a result of the fees, in recent years, successful discrimination claims of all types, not just disability discrimination, but all types of discrimination claims, have hovered at around the 80 mark per annum. So that's quite a lot of successful claims relating to discrimination arising as a consequence of disability. Now I'm going to look at some of the cases unique to this particular strand of the disability discrimination law. It's still relatively new. It's been with us for 5 years or so the cases are still evolving. And so I've got a mixture of first instance tribunal decisions, a few EAT decisions, and 1 or 2 Court of Appeal decisions. And the idea is to create a snapshot of the current situation. And finally, I'm going to look at some practical issues on avoiding disability discrimination, particularly relating to dismissal. So the types of discrimination in relation to disability discrimination, you'll see 6 there on the slide. Now the first one is direct discrimination, and you'll all be familiar with this from sex, race, age discrimination framework. Discrimination arising in a consequence of a disability or discrimination arising out of a disability is the one I'm going to be focusing on today, and this is unique to disability discrimination. Number 3 there is indirect discrimination, again a concept that you'll be familiar with. Number 4 is the failure to make reasonable adjustments, and this again is unique to disability discrimination. Then you've got number 5, harassment, and number 6, victimisation. Again, you'll be familiar with harassment and victimisation from the other strands of discrimination law. So I'm just going to focus very quickly on direct, indirect, and duty to make reasonable adjustments, just to draw out the similarities and the differences with this new strand of discrimination arising out of a disability. So in terms of direct discrimination, the key points to note here is the need for a comparator. So an employee claiming direct disability discrimination must show that they've been treated less favourably than a real or a hypothetical comparator whose circumstances are not materially different to theirs. Now, it's generally accepted that it's difficult to bring a successful direct discrimination claim, and we'll come on to an example that's contained in the Code of Practice of direct discrimination comparators, and you'll see why it is difficult for an employee to succeed in this type of claim. Now, the other point to note is that in the cases of direct discrimination and only direct discrimination, there is a need for the decision maker to have actual knowledge of disability. And this comes from the recent EAT decision of Gallup and Newport City Council. So even though the organisation might have as a whole knowledge that this individual had a disability, the test or the tribunal's inquiry ought to be on the thought processes and the motivation of the decision maker. So the test is, did the decision maker know of the disability and were they influenced by it? And note there, direct discrimination cannot be justified. So the differences between direct discrimination and discrimination arising out of a disability is there is no need for comparators in discrimination arising out of disability. There is a need for knowledge, but it can be actual or constructive knowledge, and it is possible to justify discrimination arising out of a disability. Now, the example from the Equality and Human Rights Code of Practice of direct discrimination, the comparator, is on the slide. So it's a disabled man with arthritis who can type at 30 words per minute. He applies for an administrative role which includes typing, but he's rejected on the grounds that his typing is too slow. Now, the correct comparator in the claim for direct discrimination would be a person without arthritis who has the same typing speed with the same accuracy rate. And this example demonstrates why claims of direct discrimination are difficult to bring, because the employer in this case will be able to demonstrate that they would have rejected a person without arthritis who could only type at 30 words per minute. But note, although the treatment here does not amount to direct discrimination, it could amount to indirect disability discrimination, a failure to make reasonable adjustments, and discrimination arising from a disability. So the indirect discrimination definition is on the slide, and I'm not going to go through it step by step. You'll be familiar with the concept of indirect discrimination from sex and race discrimination legislation. Now, interestingly, there was no indirect discrimination strand prior to the Equality Act 2010, so it didn't feature in the Disability Discrimination Act, because it was felt that at the time the duty to make reasonable adjustments and the then disability-related strand of discrimination afforded adequate protection. It's a difficult and technical area, and there aren't a huge number of disability discrimination cases in this area. The problems are around the provision, criterion or practice, and great care is required and expert knowledge when formulating a PCP, which the disabled person claims has been unlawfully applied. The other technical and difficult aspect of it are it's necessary for the employee to point to a provision, criterion or practice which disadvantages not just them but persons sharing their particular disability, so that there is a group disadvantage. Okay, so generally speaking, it's easier to bring a failure to make reasonable adjustments claim and or discrimination arising out of a disability claim, and this is even acknowledged by the courts. The only time that it might be appropriate to bring an indirect discrimination claim instead of a discrimination arising out of a disability claim is where the employer has no way of knowing that the employee was disabled. Because in the case of indirect discrimination, the employer's knowledge of discrimination is not required. And the only other circumstance might be where the employer requires the employee to do something that they find difficult because of their disability. Now, this treatment is arguably not because of something arising in consequence of the employee's disability, and it might not be unfavourable treatment for reason arising in consequence of the employee's disability. However, it might amount to provision, criterion or practice, potentially giving rise to indirect discrimination liability. So there are circumstances where it may be appropriate to bring it. Generally speaking, what we find are claimants tend to bring claims under each of the different strands in any event. Now, an example of indirect discrimination, which is easier than going through each of the requirements step by step, this was contained in the draft Equality and Human Rights Code, and it doesn't seem to have survived into the final code, but it still seems valid. And I think I wanted to use it as an example of why it is difficult to bring an indirect discrimination claim. So an employee with depression is dismissed by a government department because of a poor attendance record. Over a number of years, the employee has repeated periods of short-term absence relating to depression. Although the department has made adjustments by increasing the number of days she could take off before implementing its attendance policy, it has ultimately decided that it could no longer support her short-term absences. So the employee claims that the attendance management policy is indirectly discriminatory towards employees with depression. And the employer will then have to justify the reasons why it can no longer support the employee's short-term absences. Now, I've included this, even though it was in the draft Equality and Human Rights Code, because it does highlight the difficulty of an indirect disability discrimination claim, because there might be room to argue that the adjustments to the trigger points that the employer has made here, because they have made an adjustment by increasing the number of days, means that that particular provision, criterion or practice applied to the disabled employee is not in fact the same provision, criterion or practice as would be applied to persons who do not have the disability, and so therefore the claim would not be made out. So just key points to note in relation to indirect discrimination: employers' knowledge of discrimination is not required, so that's different to discrimination arising from a disability. And indirect discrimination can be objectively justified if the employer can demonstrate that the provision, criterion or practice is a proportionate means of achieving a legitimate aim. So this is similar to discrimination arising out of a disability. So the duty to make reasonable adjustments you will probably be familiar with, and it lends itself to a separate session entirely. This strand of discrimination is unique to disability discrimination, and it places a positive obligation on employers in circumstances where they know or ought reasonably to know that the person has a disability and that they are placed at a substantial disadvantage by either a PCP, physical features, or failure to provide auxiliary aids. So the duty requires three things. If it arises, the first is a duty to change the way things are done. For example, the provision, criterion or practice. It could be to providing a parking space to employees who have disabilities, even though the practice is only to allow parking spaces for certain grades of staff, or redeploying somebody to a different job without a competitive interview. So that's changing practices, changing the way things are done by the employer. The second requirement involves making changes to overcome barriers created by the physical features of the workplace. So including changes to the potential structure of premises, or placing high visibility stickers on glass doors, or widening the doors for wheelchair access. And the third requirement involves providing extra equipment, which is known as auxiliary aid, or getting to do someone to do something to assist the disabled person, which is known as an auxiliary service. So in terms of the duty to make reasonable adjustments, knowledge here can be actual or implied or constructive. Okay, so it's not necessary in this scenario for the disabled employee to declare the fact that they have a disability, for the employer to be deemed to have that knowledge. The circumstances of the employee may be such that it would be reasonable for the employer to know that the employee has a disability. Okay, so I'm now coming on to discrimination arising from disability. So this is a relatively new strand. As I said before, it was introduced by the Equality Act 2010. And for those of you who remember the Disability Discrimination Act, the backdrop is quite interesting. So under the Disability Discrimination Act, there was this concept of disability-related discrimination. And you may recall, if you were practicing or HR practitioners at that time, the Clark and Novacold case, where the Court of Appeal clarified the test for disability-related discrimination, and in particular it held that the comparator in such cases is not the same as in other areas of discrimination law, in that they do not have to be the person whose material circumstances are substantially the same. So they must be someone to whom the reason, or the reason for the claimant's treatment, does not apply. So just in a nutshell, if a disabled person is dismissed for absence and the absence is related to the disability, the correct comparator under Clark was to ask whether a person who was not absent would have been dismissed. Okay, so that made it relatively easy to bring a disability-related discrimination claim under the Disability Discrimination Act. So what happened was things were going nicely, trundling nicely under the Disability Discrimination Act, and then we had the House of Lords case in London Borough of Lewisham and Malcolm, and this wasn't actually an employment case at all, it was a provision of goods and services case. And in this case, Mr. Malcolm had schizophrenia and he'd illegally sublet his flat, and as a result the council had evicted him, and he argued that this was disability-related discrimination. And it went to the House of Lords, and the House of Lords considered the Court of Appeal decision in Clark, and the question was whether Mr. Malcolm was treated less favourably than somebody who'd not illegally sublet the flat. So applying the Clark comparator, that essentially was the question the House of Lords had to pose. Would Mr. Malcolm have been treated less favourably than somebody who had not illegally sublet the flat? And the Lordships held that this was the wrong comparator, and that the correct question was whether he'd been treated less favourably than a non-disabled comparator who had illegally sublet the flat. And that basically severely limited the disability-related discrimination strand. And what that meant was that when the Equality Act 2010 came into force, the government introduced this concept of discrimination arising from disability, and according to the explanatory notes, it was aimed at re-establishing an appropriate balance between enabling a disabled person to make out a case of experiencing a detriment which arises because of his or her disability, and providing an opportunity for an employer or other person to defend the treatment. So, the definition of discrimination arising from disability is there on the slide. So A treats B unfavourably because of something arising in consequence of B's disability. And A, the employer cannot show the treatment is a proportionate means of achieving a legitimate aim. So note that there is no comparator required here. The reference is to unfavourable treatment and not less favourable treatment. Now also note that there is a knowledge required of disability by the employer, but this knowledge is the same as knowledge in the case of duty to make reasonable adjustments. It can be actual or constructive. And an example in the Equality and Human Rights Code of Practice of discrimination arising from disability is an employer who dismisses a worker because she has 3 months sick leave. Now, the employer is aware that the worker has MS and that most of her sick leave is disability related. The employer's decision to dismiss is not because of the worker's disability itself, so it's not because of her MS, it's because of her disability-related sick leave. And therefore, by dismissing the employee for the disability-related sick leave, she can demonstrate that she's been treated unfavourably because of something arising in consequence of a disability. So her sick leave is as a consequence of her MS. So that's the definition in a nutshell. So there is the standard objective justification test that we'll come on to. It's a very low hurdle, as we'll see from some of the cases that I'm going to go through in a minute. It's a very low hurdle for a claimant to satisfy a Section 15 claim. Section 15 claim is discrimination arising from disability. The way the employer can defend a claim is if it can demonstrate that it did not know and could not reasonably have known that the claimant was disabled, failing which, if it has subjected the claimant to unfavourable treatment, that it was a proportionate means of achieving a legitimate aim. And when relying upon that defence, the proportionate means of achieving a legitimate aim defence, you have to first look at the legitimate aim. What reason is the employer putting forward to justify its treatment? And then you secondly have to consider, well, okay, that might be a legitimate aim, but is it proportionate? Were there any less discriminatory ways of achieving that legitimate aim? So there has to be a balancing act between the discriminatory treatment suffered by the employee against the legitimate business requirements, if you like, of the employer. So I'm going to look at some examples from case law now with some contrasting results. And the first one is, can dismissal for disability-related absences amount to discrimination arising from disability? Well, I think the answer is yes. And the first case on there is an employment tribunal case. It's quite a recent case. It's Powell against the Secretary of State for Work and Pensions. Now, this was a case involving, I'll give you some of the facts. Mrs. Powell, she had 34 years service. And she was ultimately dismissed after she had exceeded the trigger point under the employer's absence management policy. Now, the evidence from the tribunal was that she was a highly valued, popular and competent member of staff. She started in 1980 and then in 2001, so 21 years later, she started suffering from premenstrual syndrome, which was accepted by the employer to be a disability. And then from 2001 till 2011, she was frequently off sick, and the decision was made to dismiss her initially in 2011, but she appealed against that decision, and the decision was overturned. And as a consequence of that appeal, the employer adjusted her trigger points. So whereas under the normal procedure, it was an 8-day trigger point system, so once the 8 days absence had been accumulated, further action would take place, and the employer extended this to 12 days. So under the procedure, you'll probably be familiar with the trigger point procedure, which required a series of warnings, a final written warning. There was a consideration point at which the line manager could either decide to refer the employee to a decision maker or not, as the case may be. And when the employee was referred to the decision maker, it was for that decision maker to determine whether dismissal or demotion should occur, or whether to maintain the status quo. So it's clear that dismissal was as a last resort. So following the successful appeal in 2011, from late 2012 to mid-2014, she had a number of absences that meant she exceeded a trigger point. There were a number of review periods and sustained improvement periods. And then she was hospitalised in July of 2014 for a reason unconnected to a disability. By now, she'd exceeded a trigger point by a number of days, with 5 or 6 of those days being attributable to her disability. And in July 2014, the employer finally decided to dismiss her on the grounds of her inability to sustain satisfactory attendance. So this went to tribunal. Mrs. Powell argued that the dismissal was discrimination arising out of her disability, because they had dismissed her because of her absence record, and her absence record arose because of her disability. Now, when it went to tribunal, the employment tribunal considered the employer's legitimate aim, and it was satisfied that it did have a legitimate aim of reducing sickness absence and maintaining an efficient service, and that this was legitimate. However, it held that the employer's approach was not proportionate. So this is where the objective justification test fell down. So the discrimination sustained by Mrs. Powell vastly outweighed the employer's legitimate aim. Okay, so she'd only exceeded a trigger point by a few days. Her absences were related to a disability, and the tribunal also held that every time she reached the trigger point, she was subjected to this quasi-disciplinary action. So what the tribunal said was the employer had failed to consider her length of service, 34 years, and that the effect of her dismissal would mean that she was very vulnerable in the open market. It would be very difficult for her to find another job, and that therefore this outweighed by a significant margin the employer's legitimate aim. And interestingly, it did say her absences were bound to lead to some disruption to the employer, but that an employer of this size should be capable of accommodating her absences. So an interesting case there, and I think it highlights, if you like, the lengths at which a tribunal may require an employer to go to accommodate a disabled person's absences. Now, there is a paucity of guidance from the courts as to how far an employer has to stretch to accommodate an employee's disability-related absences, and you have to bear in mind this is a first instance decision. But I think it's quite an important case to be thinking about in circumstances that you may have. I've mentioned the Griffiths versus the Secretary of State for Work and Pensions there. This isn't on the issue of discrimination arising from disability. This is more about the duty to make reasonable adjustments. And I think this case does highlight the difficulty with identifying the correct PCP. But what it does do, I think, is it highlights, and the court itself, the Court of Appeal said that parties and employment tribunals should consider carefully whether the duty to make reasonable adjustments really is in play in absence management policy cases or dismissal for absence type cases, or whether the case is best considered and analysed under the new robust Section 15, i.e. discrimination arising from disability strand. So what the court is essentially saying there, it's much easier to bring a claim under Section 15, discrimination arising from disability, than under the duty to make reasonable adjustments. So the next slide is dismissal for inappropriate behaviour. And the first case there is Nally, and I'll just run through some of the facts very quickly. So he was, Mr. Nally was a care home worker looking after elderly residents, and after about 18 months of employment, he told a resident with dementia to shut up. And he had a meeting with his deputy manager to discuss this incident, and he informed her that he had post-traumatic stress disorder and he'd been experiencing some anxiety issues. Now, the deputy manager informed him that she was going to be monitoring his behaviour for a 2-week period and asked him to provide his doctor's details so that she could obtain a medical report. Now, 2 weeks after the meeting, the claimant had a huge argument with another worker, and the next day he was asked to attend a meeting with the manager and deputy manager, and he was effectively dismissed. Now, I imagine at this point the Freshfield Care Limited were thinking he's only got 18 months service, let's dismiss before he acquires the 2 years. So he couldn't bring an unfair dismissal claim. But what he did do was he brought various claims under the Disability Discrimination Act, including unfavourable treatment because of something arising from his disability. And here, what he said was his disability was post-traumatic stress disorder, and that had led to his unacceptable behaviour. And the employer had dismissed him for his unacceptable behaviour, but it related to, or it was as a consequence of his disability. Now, the employer tried to deny knowledge of his disability and said that he'd not told them explicitly that he had a disability. The tribunal did not accept this and said that they became aware that he was disabled or potentially disabled at the first meeting to discuss the incident. And this was not a proportionate means of achieving a legitimate aim. It accepted that a legitimate aim was an acceptable level of behaviour in the workplace. However, the employer had not could not objectively justify the dismissal because there were alternative, less discriminatory ways of achieving that legitimate aim. Instead of dismissal, it could have suspended him, or it could have issued him with a warning, making it clear that such behaviour in future would not be acceptable. It could have obtained a medical report to understand what his condition was, to make an informed decision. And for that reason, the employer failed in its justification defence. So then I'm just going to touch quickly on the Burdett and Aviva case. And this was Mr. Burdett was a paranoid schizophrenic, and he was dismissed for sexually assaulting female colleagues and a member of the public. Now, this assault, or these assaults, happened after he discontinued his medication without medical approval. Now, this is an EAT decision, and at first instance, the Employment Tribunal held that although the dismissal potentially amounted to discrimination arising from disability, it was a proportionate means of achieving Aviva's legitimate aim, which was maintaining appropriate standards of conduct in the workplace and safeguarding its employees. The tribunal at first instance rejected the discrimination claim. However, on appeal, the EAT disagreed. And what it said was that the tribunal had not carried out the requisite balancing exercise when deciding that dismissal was proportionate, and it had given too much weight to Aviva's legitimate aims over the potential discriminatory effects of dismissal on Mr. Burdett, who was going to have great difficulty in finding alternative employment in the open market. So these cases are to be contrasted next with the Hensman against the Ministry of Defence. And this is again an employment appeal tribunal and almost the reverse of the Burdett and Aviva. So Mr. Hensman suffered from Asperger's syndrome, and he received a criminal conviction for covertly recording a colleague in the shower area of shared accommodation provided by the Ministry of Defence. So the tribunal decided that the dismissal amounted to discrimination arising from disability, because the reason he had been dismissed was because of his behaviour, which was in turn a consequence of his Asperger's syndrome. Now, the tribunal at first instance decided that dismissal was disproportionate, i.e. that the employer could not demonstrate proportionate means of achieving a legitimate aim, because the Crown Court judge on the criminal case had held that he was not at fault for his crime because of his abnormality of mind. Further, the tribunal said that the MOD was a large organisation and could have transferred the employee if necessary to protect the victim. Again, it should have considered Mr. Hensman's long service and vulnerability in the open labour market, so this was not a proportionate means of achieving a legitimate aim. Now, at this stage, the EAT, so MOD appealed, and the EAT overturned the tribunal's decision, holding that it had failed to carry out, again, the appropriate balancing exercise. So in this case, it had failed to consider the legitimate aim of the employer. And those issues that were weighing on the employer's mind relating to breach of trust and the fact that the filming had been covert and the need to protect its other employees. So what happened here was the EAT remitted the case to a fresh tribunal to consider the employer's legitimate aims. Now, McGraw and London Ambulance Service is a different type of case, really. It was basically where the employee was not able to demonstrate that his actions did arise out of his disability. So I won't really, I'm conscious of time, so I won't go into that particular case. So the next case is the withdrawal of a job offer based on a negative verbal reference, and can that amount to discrimination arising out of a disability? And this is an EAT decision in the case of Naser against the NHS England. And this is a case where she had been employed by Coventry City Council, and her disability meant that she had a number of lengthy absences and regularly needed to work at home. However, her line manager's assessments of her performance were always positive, and as part of a restructuring exercise, she agreed to be made redundant, and she entered into a settlement agreement where she would be provided with a basic reference stating that she always carried out her tasks to the best of her ability and worked diligently. Now, she applied for and was offered a position with NHS England, subject to satisfactory references. And in the evidence, the interviewer had apparently described her as an excellent candidate. However, the job offer was withdrawn following a telephone call between the interviewer and her former manager, who had provided a reference in the agreed form. So clearly a conversation took place, and there were factual disputes as to what was said during the telephone discussion. However, it was apparent that the former line manager had raised doubts as to her suitability to undertake the role. And as a result of that, the offer was retracted. Now, she brought claims against both her former and prospective employers, arguing unfavourable treatment because of something that had arisen as a consequence of a disability. And the Employment Tribunal initially, at first instance, rejected her claim because it concluded that whilst the line manager's negative comments and the withdrawal of the job offer were unfavourable treatment, she had failed to make out a case that they were related to her absences. So this is where the Employment Tribunal had found that she had failed to overcome the test, which, as we know, is relatively low. The Employment Appeal Tribunal, however, overturned this decision and said, given the evidence, the Employment Tribunal should have concluded that the line manager's negative comments about Mrs. Naser arose as a consequence of her disability. And instead of remitting it to the Employment Tribunal for fresh consideration, it's instead substituted a finding that both her former employer and her prospective employer had committed unlawful discrimination, contrary to Section 15. On a similar vein, the case of West and Yorkshire Ambulance Services, again, a tribunal case, but this was where a job offer was withdrawn because of the individual's sickness absence in a previous role. And in this case, Mrs. West was a nurse with a disability, and she made no secret of a disability, and she applied for a post with NHS 111 as a helpline advisor. Her employment with her previous employer had been terminated with consent following an 18-month absence because of a disability. So she was offered the post, the new role, subject to satisfactory references and an occupational health assessment. On receiving the reference and the occupational health assessment, the prospective new employer withdrew the conditional offer of employment. And it would appear from the evidence that there were two reasons for this. The first was that her previous absence because of ill health had led to an assumption that she would not be able to perform the role to the required standards. And there was also a brief report after a 20-minute telephone conversation from occupational health, which suggested that she would need to take a break every few minutes. However, that wasn't in fact the case. The employer here misunderstood the occupational health advisor's report. And what happened here, the employment tribunal accepted the job offer withdrawal was unfavourable treatment because of something arising in consequence of a disability. And what it struck the tribunal was the rapidity in which the job offer had been withdrawn, because Mrs. West had made no secret of a disability or her previous sick leave. And the tribunal couldn't understand why the employer had not simply spoken to her, and to understand, you know, her level of attendance, and you know what would be required, enable her for her to perform the role, if anything at all. So the tribunal felt that it jumped to stereotypical assumptions here, and had failed to do a very simple thing, which was to consult with Mrs. West. They'd simply withdrawn the job offer based on a negative reference and the report from the occupational health advisor. So it rejected the employer's objective justification defence. And the objective justification defence was that it had a legitimate aim in recruiting people who could actually perform the job. And what the tribunal said was, well, you didn't know that she couldn't do the job. You based your decision on documents without consulting with her. And I think that's the key here. It was a fairly simple thing to do for the employer, the prospective employer, to speak to Mrs. West direct and discuss the report and discuss the reference. So, refusal to pay a performance bonus. So this is an EAT decision, the Land Registry in Horton and others. You might be familiar with this case. Because there's been quite a lot of publicity around it. But the Land Registry operated a discretionary bonus scheme, and under the terms of the scheme, employees who had received a formal warning during the financial year were not eligible to receive a bonus. Now, interestingly, formal warnings that had been received for conduct-related matters could be ignored at the manager's discretion. However, there was no such discretion when ignoring a warning in relation to sickness absence. Now, 5 people claimed discrimination arising out of disability against the Land Registry because they had not received a bonus and they had all been absent due to sickness. They'd received a sickness absence warning and they all had disabilities. Now, the Land Registry could point to reasonable adjustments that it made before the claimants actually reached the point at which they received a warning. So they could demonstrate that they had adjusted the trigger mechanism, they'd extended the number of days, that they had made adjustments to the physical arrangements for some of the individuals to remove any disadvantages that they had at work. So there were a number of reasonable adjustments that had been made. However, despite the adjustments, each of the claimants eventually did receive a warning. And these warnings made them ineligible for a bonus, so they did not receive a bonus. So the Employment Tribunal accepted that there was a link between the discrimination, i.e. the unfavourable treatment, and the disability. So the reason that they had been subjected to unfavourable treatment was because they had received an attendance warning, and that attendance warning was a consequence of their disability. So that was made out, and the Land Registry attempted to justify its actions, stating that it had a legitimate aim of acknowledging employees' contributions and encouraging and rewarding good performance and attendance. However, the tribunal and the EAT agreed that the bonus scheme in place was not a proportionate means of achieving that legitimate aim. And in particular, what struck both the Employment Tribunal and the EAT was that there was no mechanism, there was no discretion to take into account that, you know, in certain cases, the claimants had improved their absence record after receiving the warning. And they felt that there was an anomaly in the scheme where conduct-related warnings could be ignored, but no warnings for sickness absence could be ignored. And I think in this decision, and it's very clear from the decision itself, that it was the lack of discretion in the case of absence-related warnings that rendered this policy incapable of being justified. So had the Land Registry introduced that discretion, it might have been possible to justify the bonus scheme as a proportionate means of achieving a legitimate aim. So, requiring employees to attend competitive interview processes during redeployment exercise, can that requirement amount to discrimination arising from disability? And I suspect you'll be thinking, well, yes, because that's the nature of these cases that we're looking at. It's a relatively, as I say, it's a relatively low hurdle for an employee to claim discrimination arising from disability. And there are two cases, the Waddingham against the NHS Business Service Authority. This is an employment tribunal claim. And in this case, Mr. Waddingham had been employed for a number of years by the NHS. And there was a reorganisation, and he was allowed to apply for new roles within the reorganised structure. And those who were going to be applying for new roles had to attend a competitive interview for the internal posts. Now, he had just started receiving cancer treatment, and it was throat cancer treatment, and he was on strong medication at the time. Now, he made very little of that and said, oh no, that didn't affect his ability to attend the competitive interview process. So he indicated his willingness to attend a competitive interview process. But at that interview, he scored very low. So he scored as 57 marks rather than the 75, which is the benchmark pass mark. And as a result, he was dismissed by reason of redundancy. Now, he brought various claims, including disability arising as a consequence, discrimination arising as a consequence of disability. And what the tribunal held was that whilst it was necessary to have some form of assessment, it wasn't necessary to have a competitive interview in relation to Mr. Waddingham. The employer knew that he was disabled. They knew he was having treatment for throat cancer. And this had clearly impacted his performance during the competitive interview process. So the employer had failed to make reasonable adjustments in this case because it could have used a less discriminatory way of achieving the same outcome. So they could have dispensed altogether with the competitive interview process and looked at Mr. Waddingham's past performance because he was a long-standing employee. They could have looked at how he performed in previous roles. And the failure to appoint the employee to the role amounted to discrimination arising from his disability because he was unsuccessful because of his poor performance at interview, which had been adversely affected by his condition. Now, interestingly, when defending this aspect of the claim, the employer tried to argue that it was a legitimate aim to select the best candidate for the job. The tribunal doubted whether this could be a legitimate aim in a context where a disabled candidate is applying for a role, because the disability discrimination provisions in the Equality Act allow more favourable treatment to be given to a disabled candidate than a non-disabled candidate. And what the tribunal held was that a more appropriate aim may be to appoint a person who could perform to the required standards. And they felt that based on Mr. Waddingham's past history, that it could be demonstrated that he could have performed to the required standards. So this is a clear example of an employer's positive obligations to consider what adjustments may be reasonable when, say, dealing with a disabled person. what was interesting was that Mr. Waddingham had put a very positive spin on his ability to attend the interview process. And the tribunal said that this positive spin was understandable in circumstances where he faced losing his employment, and it should not have been accepted at face value by the employer. The employer should have looked beyond this and taken into account the effects of the medical condition and the treatment on his ability to perform at interview. Again, quite a salutary case there. And the other one is London Borough of Southwark and Charles, in similar circumstances, and this was more about an employer's failure to make reasonable adjustments. And again, this is an EAT decision. The EAT, in this case, upheld the tribunal's decision that an employer had failed to make reasonable adjustments for a disabled employee in a redundancy exercise because the employee's disability meant that he was unable to attend administrative meetings, which the tribunal held would include interviews. So the tribunal here found that Mr. Charles had failed to attend an interview, and even though the employer had agreed to make adjustments to the interview process, so they knew that he had a disability, they had agreed to delay the interviews for him. They had offered him regular breaks during the interview process. So there were a number of reasonable adjustments that the employer had offered to Mr. Charles, but ultimately the tribunal held that that was not sufficient. The reasonable adjustments would have been dispensing with the need for him to attend the interview at all. Again, Mr. Charles had been there for quite some time, and it would have been possible to assess his capability by looking at his past performance in roles. And in this case, even though it was a case of failure to make reasonable adjustments, the Employment Appeal Tribunal also found that it would have amounted to a discrimination for a reason arising out of a disability, and that it would not have been possible for the employer to objectively justify that discrimination. And finally, I thought this was quite an interesting case. It's the Risby against London Borough of Waltham Forest. It's quite a recent EAT decision. And here, the Employment Appeal Tribunal held that there only needs to be a loose causal link between an employee's conduct and their disability, where discrimination arising from a disability is claimed. Now, just to put this into context, the facts are that Mr. Risby had paraplegia. Now, he was summarily dismissed after he lost his temper at work and used very racist and offensive language after he'd learned that his employer had relocated a course that he wished to attend to a venue which was inaccessible to him as a wheelchair user. So when he found out, he clearly lost his temper, made some very unfortunate racist comments. The employer felt that his behaviour simply could not be tolerated, was contrary to the Equal Opportunities Policy, and therefore they dismissed him. Now, during the tribunal evidence, it was held or found that Mr. Risby had a tendency to lose his temper, but this was a personality trait and unrelated to his disability, which was paraplegia. So for that reason, the Employment Tribunal found that there was no direct link between Mr. Risby's behaviour and his disability. So he therefore dismissed his claim for unfair dismissal and discrimination arising out of a disability. However, the Employment Appeal Tribunal disagreed and found that the situation only arose because Mr. Risby was disabled, i.e., if he'd not been disabled by paraplegia, he would not have been angered by the decision to relocate the workshop. So, the EAT felt that Mr. Risby's conduct was a product of a situation he found himself in because of his disability, and therefore held that the Employment Tribunal was wrong to dismiss his discrimination claim. So it's referred it back to the Employment Tribunal to determine whether or not the dismissal in this case was a proportionate a proportionate means of achieving a legitimate aim. So that's quite an interesting one in terms of the causal connection. And then finally, and I'm conscious of the time, I was just going to look very quickly at the practical issues. And clearly from these cases, the law entitles those who are disabled to special and sometimes more favourable treatment. And very often when employers phone for advice, they're never actually sure whether the individual in question has a disability or not. And the sense is, well, let's not make inquiries because what we don't know can't harm us. However, the employer has to be proactive. And they have to, in the context of this discrimination arising from disability and also in the context of a duty to make reasonable adjustments, it has to do everything it can reasonably be expected to do to find out. And it's worth finding out because if there is a dispute as to whether an adjustment or a step is reasonable or if the employer wishes to rely on objective justification, the employer is going to be in a better position if it's aware of the disability, has expressly considered its duties in relation to the disability and what adjustments it can make, and has consulted with the employee and considered any suggestions by the employee. It's in a much stronger position to defend any claim or justify its actions. Now, dismissal on account of absences, I think the Powell case indicates that there is a paucity of guidance from the courts as to how far an employer has to stretch to accommodate an employee's disability-related absences. Because, you know, under the old law, under the Disability Discrimination Act, there was an EAT decision, the Royal Liverpool Children's NHS Trust in Dunsby, where the EAT said that disability discrimination legislation does not impose an absolute obligation on an employer to refrain from dismissing an employee who is absent wholly or in part on the ground of ill health due to disability. Now that was under the old Act, and that was where the objective justification test was much lower. It was a much easier test for the employer to satisfy. Now we've got the standard objective justification test, and we only have first instance decision. So it will, you know, we need some more EAT or Court of Appeal guidance here. So questions for the employer is, do you discount them entirely from your absence management procedure? Query whether you do, but at the very minimum, you will have to adjust the number of absences that would trigger an absence warning, and query then if that will be sufficient. So dismissal on account of long-term disability-related sick leave, where somebody has been off on long-term sick leave, consider alternative dismissal. You know, obviously you will be familiar with phased return to work. Consider whether to redeploy the employee to a role where the effect of his disability does not place him or her at a substantial disadvantage. You know, there have been some cases where it's held that it was reasonable for the employer to create a new role to take account of the disability. And this is taking this concept of the obligation to treat people with disabilities more favourably, positively discriminate in favour of them. Now, practical issues on redundancy. Generally, in normal redundancy cases, so where you don't have claims for discrimination, provided the selection criteria are objective, the tribunal will not apply over minute scrutiny of those criteria or how they're applied. However, if you have a disabled employee who claims discrimination, the tribunal will thoroughly scrutinise the employee's selection criteria for signs of discrimination and will consider whether they have been applied in a discriminatory manner. So problematic selection criteria are attendance records and sickness absence records. Because clearly, if you are going to include this, it's going to have a disproportionate impact. It's going to place disabled persons at a substantial disadvantage compared with non-disabled. So this gives rise to the duty to make reasonable adjustments. Furthermore, if you were to score the employee low because of unacceptable attendance records, that is clearly discrimination arising as a consequence of a disability. So you need to consider adjusting the scoring, perhaps to discount some or all absences for disability-related reasons. Productivity is another one that employers like to use because it's objective and the employer can be left with a more efficient workforce if it selects people based on productivity. However, again, this is potentially disadvantageous to disabled employees whose disability may have a negative impact on productivity. Again, this potentially rises to a failure to make reasonable adjustments, indirect disability discrimination, and in particular, discrimination arising out of a disability. So one consideration would be to consider an adjustment such as giving the employee full marks for productivity when his or her score would otherwise have been low. Now you could say, well, that's not fair to other employees caught up in the redundancy exercise. But you have to remember that it's permissible to treat a disabled employee more favourably, and there is a degree of positive discrimination almost expected, I would say, from the courts. Flexibility is another one where employers like to use it. For example, willingness of staff to relocate or to work and social hours, or to carry out a wide variety of tasks. And the Code of Practice, the Equality and Human Rights Commission Code of Practice, warns that the use of flexibility as a selection criteria does run the risk of a finding of disability discrimination. So again, if you're going to use flexibility, you must consider, for those who have disabilities, making a reasonable adjustment to this particular marking. And then when it comes to alternative work, well, we've considered those cases where, for example, the requirement for a person to attend a competitive interview process has been held to be discriminatory. So I think, it's almost analogous now with giving an employee on maternity leave priority in relation to an alternative role. So there is a positive obligation under the legislation. If a female is on maternity leave and there is a suitable alternative role, the employer must offer it to her. I think it's analogous in relation to disability discrimination. From the case law, consider whether or not a suitable alternative role should be offered to a person with a disability, so long as they are capable of performing that role. And I've run over by 5 minutes, so I do apologise, but I don't think I found any questions have arisen. No, but if you do have any questions, then get in touch with your usual gunnercooke contact. Thank you very much.